This is the first lecture in the legal process, Montreal Moot Court class. So let me explain the structure of things here. You have, hopefully, already begun to read, and you're a few lectures in. This means that some of the material should be familiar so I can elaborate on it, and you'll be able to follow it more readily. Where possible, I will denote pages from the actual handouts you have, so that you can go there and highlight what I am reading from that particular page, and then I will elaborate on it, and there should be room in the columns for you to write that elaboration. So if nothing else, if you're underlining, and you should read everything, but if you're underlining based on the page and so on, what I'm reading before I comment on it, that makes it very clear. Read it, comment, and you have all the notes you need to really understand the material. Some comments will be general, some will be very specific. So you should really keep in mind that that is how the course will operate. Okay? Now, a word about these lectures. The lectures will run somewhere between 45 minutes and an hour and 15 minutes. I will try and keep it at 45 so that it's sort of more succinct if you need to go watch them again. When you watch a video, if there's something you want to highlight, mark the timestamp it for yourself, so that basically you can go back to it. Keeping in mind that if I'm reading from the materials and then elaborating on them, I'm giving you a page number, and you can timestamp where that occurs. There should be no confusion in this format, or very little confusion in this format, relevant to the material itself. That's the idea. Okay, so that's the process you should take. A couple of warnings. One, do not binge watch these videos. It's just not. I'm just not that good. You're not gonna find this to be necessarily something you want to watch over and over again, or watch several hours of in a row. Plus, things fade from memory. Right. Somehow there's a connection between your hand and your brain. So if you're writing notes and all that, that's what you should review, and just go back and look at those pieces of the video, again, time-stamped, that you need to hear again. If you keep up with that, all the readings for the midterm will be taken care of. Also, by knowing and I would recommend you do this, it may sound elaborate, but on a separate sheet of paper, if you note every place you've had an issue, and you mark the page, and you timestamp it, and you mark the video it's from, lecture 1, lecture 2, lecture 3, it should be very easy to study. Plus, the midterm exam as the final, they're open note, open book. It's too hard to limit that, right? So knowing where the material is really helpful. Also, it's a lot easier to integrate it for yourself in your, in your own mind. Okay, I do these videos much like I would lecture in class. So that means I have no problem stopping, taking a sip of water, doing something else. I may stop the video for a second or two because I want to think about something, or I want to get something maybe additional on the board. That's unlikely, but it's possible. So if you see what looks like the video has frozen, give it several seconds. I don't do that very much at all. So, but if it happens, I don't want you to go back and think something's happened to the video. I've just paused it. Give it some time, and it's probably a little herky-jerky when it comes back up. All right, so let's get started. First of all, you were probably curious or surprised that the first chapter you're responsible for reading, and really the entire class, is going to be about writing. Now stop. It's not about you learning how to write in terms of, generally. We explore the process Montreal Moot Court approaches, because law is about writing. You can't get away from that. A lawyer's stock in trade are words. And if you've taken other classes with me, or you're taking a class with me now, let's say in constitutional law, you'll hear me say that, because that's what it comes down to. In the law, everything is written, whether it's policy or whether it's a memorandum. We write. And writing, even for first-year law students, I think is always surprising because they assume they're learning the law. Well, this is how you learn. You learn how to express your ideas, and there's an approach you can take with wiggle room for how to do it. But there are specific things and approaches and purpose behind writing everything. That being said, there's never a way to calm student fears about this. So I'm going to start off by frightening you, I guess, a little bit, but please don't be. It's so specific to writing that you'll get books like this, Elements of Legal Style. And in it, there are several chapters on organizing your arguments. It's a great book to sort of read and go through because it lays out everything for you and then gives you terminology so that basically you can look it up. So the first, I guess 100 pages is really about the writing, and then it goes into terminology. So you can look up various terms, and you should get a copy of it if you're serious about maybe going to law school. This never hurts. Okay, if you're going to go to law school, and not for this class, thankfully, there's the dreaded Blue Book, Uniform System of Citations. All the markings because I was working on something, so ignore those. But the bottom line is, I can't say everyone, but I've never had anyone say, I love this book. I take it with me everywhere I go. Students suffer through this, and most law professors will hold you accountable for citing things correctly. If you're on law review, people that are writing, lawyers and judges, they don't like doing this. So part of the law review job is, hey, great, cite, here's where I got this stuff from, cite it properly. So no one really loves this stuff. Plus it changes. Plus there are different courts that want it different ways. Plus different states, that sort of thing. So it's the Supreme Court changes things. We want it done this way. So, there are new editions. This is an older edition, and it's the 20th. So that tells you something. You'll get this book if you go to law school. And again, I'm not assuming everyone in this class is doing that. I just want to, make it, put things in context. It's the one book you'll probably be very willing to get rid of. It's not one that people hold on to necessarily. And there's software that tries to cite, but it's usually not as accurate as maybe it should be. All right. So no escaping writing, because writing is a clear exposition of ideas. And in law, that's what you're doing, right? Think about it. Legislation, policy, regulation, all verbiage, court decisions, typically written out, right? Especially for the Supreme Court in the here case. There's what we really cling to is what they've written. And there's a purpose behind this. You have to clearly express what you want, what you think the issues are, and your argument for it, right? And there are different types of writing which we'll go over, but their purpose is the same. Clearly establish ideas and your particular point of view. You're instructing the court, or maybe a partner in the law firm you work for. So process is really about all of that. Okay, process is the writing of ideas. Again, if you're writing policy, if you're in a legislative body or a regulatory body, and you're writing rules about how things should happen. That's what it is, right? Here's how things should happen. And here's where there's a deviation and it's problematic. We spend a lot of time, you look at a Supreme Court case and you read it, you spend a lot of time trying to interpret words. It's surprising to some people that when there is a written decision, that justices go through great pains to define words, to define terms. And the answer is simple. They want to make sure everyone agrees about what the words mean. If the law is about anything, it's about consistency. A bylaw that's not consistent is of very little use, right? You have to know exactly what it is that piece of legislation or regulation or what have you, you have to know what the words mean. And they have to be consistently interpreted. So everyone knows what the law is. Everyone knows what the rules are. Everyone can follow it. And when there's a deviation, courts have to start all over again, or defining words, or legislative bodies or regulatory bodies have to write, new regulations or new legislation or what have you. Even the Constitution, when we realize that it needs to be changed in some way, we write an amendment, and then people agree to it. There was an argument a while back that the Constitution of the United States was not legitimate because the states had to ratify it, and each state interpreted things differently when they met in session. And so they were ratifying different documents. So there wasn't a consistency. That idea has been rejected. If for no other reason, then you can't get rid of the Constitution and start from scratch. That we're better off adjusting and redefining and that sort of thing. So you have to remember that everything you do is about putting things in written form, and that the approach for doing that is, while there's wiggle rooms and that sort of thing, that there's pretty much a format for doing that. Because again, format gives consistency. So when the justices are reading the decisions, or the panel, whatever it is, or a partner in a law firm, and you're writing a memorandum of law and you're trying to get, they don't have a lot of time to read everything. They want to know, cut to the chase. What's important here? And how are you going to approach it? Now, as an aside, which you have sometimes, obviously, actually more than sometimes, is a particular law might have, like criminal law especially, would have varying degrees of, how it's assessed, and they'll also have, when there's a breach of it, they'll also have elements of law. And sometimes, when you take a piece of legislation or a rule and you break it into its component parts, right? Those are the elements. And in some cases, all the elements have to be satisfied. The facts have to support that each element, right, has been satisfied or activated, if you will. Sometimes it's, you need just two of the four elements, and then the law can be applied. So that's just a matter of knowing, based on the legislation itself, it'll say. So if you're writing something, you're obviously writing about whether or not a particular element in it has been satisfied. All right, but it's writing. So you have to read, and you have to understand that clarity and brevity are really important. All right, so let me just start. Now, we're in chapter 1, and we're on page 3, and this lays it out very quickly. I've already touched on most of this, but I want you to be aware of it. It says, much of this book addresses matters of content and substance in legal writing, which are qualities relating sound legal analysis and to the accuracy of statements on which courts and clients rely. Now, when they say clients, you may have someone that comes to your law firm, and I'm going to pretend that you're all going to be lawyers, because that's, or you want to be, or you're just really curious about the process. So we'll get into some depth on this. A new client, or maybe an existing client, will come and speak to one of the lawyers in the firm, and will say, I really want to do X because I think there's some sort of breach contractually, or because I think some other regulation or law, or somehow I've been aggrieved. And before the law firm takes it, they listen to the facts, and they'll take those facts and they'll turn them over to someone of junior status, and they'll say, write a memorandum on this. I want to know whether we should take this case or not. And the importance of that gets laid out, the strengths and weaknesses of the case are pointed out, and then a recommendation is made from the person writing it that, and it's never definitive. It's never like, don't take this case. It's that we're unlikely, to win, or we are likely to win. And that's what we want to know, or that's what the lawyer that assigns it, or the partner wants to know. If we're likely, what are our strengths in this case, and where are we weak? If we're unlikely, where are our weaknesses, and can we overcome those? And then they make a decision, and then they go to the client or prospective client, and they say, we're not going to be able to take the case, or we will take it. If we're not going to take it, they could elaborate, because here's really the problem. And this is going to be a problem that's going to be very difficult to really get past. And so we don't think we can win this one. And you owe that to your client because you don't want them to walk down a blind alley and you know it's a dead end, right? That doesn't serve anybody, all right? So when we think about the writing, and we're not talking now about legislation or any of that. We'll bring that up and I'll allude to it, but I'm not really interested in going through specifics of a piece of legislation other than to illustrate some point. But on that page, it also, your legal memorandum will not enlighten, nor will your brief persuade. Okay, look, your memorandum, as I just said, is going to go to, let's make it simple. It's going to go to some attorney in the firm that you work for, right? Memorandum of law. Here's what the deal is. When you write a brief, notice the word is brief. When you write a brief, you're trying to persuade a court. Hey, here's the law. Here's how it gets interpreted. Here are the facts. You should throw this thing out. Or, it was clearly a breach of something, right? And therefore it should move forward. So, again, you want to do that in a concise manner. Those that are reading, if it's convoluted and it goes on forever, it's going to be problematic, right? It's going to be very problematic. Why? There are time pressures. There are limitations on these justices, and they don't want to read a dissertation. Brevity, right, is important. So on page 4, it says, effective legal writing reflects the application of principles of good writing generally. And further down, in preparing an office memorandum, the associate, right, the person doing it, will analyze whether, they use harassment here, the harassment constituted, and it's quote, extreme and outrageous conflict. Those are words. What makes something extreme? What makes it outrageous? How do we define those things? Think about the death penalty. Constitution says, right, that if you're going to, punishment, right, should, and especially in the death penalty, right, it shouldn't be cruel and unusual. How do you define those things? Well, the court looks at it and says, we've been executing people for a long time. That's not unusual. So it's very hard to get a death sentence overturned by the court based on unusual. Something can't be unusual if it's done all the time. Now, for a lot of people, that seems, that's just not right. There should be more to it than that. No, it's not unusual. So then the point becomes, what about cruel? Now, again, we've been doing things for a long time, and we've been humane, and so it's really not cruel. That's why you have, you're not going to have a lot of death sentences overturned, 11th hour sort of by the court. In fact, typically the Supreme Court has one justice that gets that and makes the decision for pretty much everybody else because it's pretty well established. But things change. So a while ago, what we had an important new fact that made the process cruel. And the court said, you got to fix this. And what was it? Well, usually, execution by injection had two parts. One where it would relax the person and where the person would feel no pain. And then the second would be the lethal injection that would end the person's life. What was discovered was that first injection, the person was aware and was in pain, but they were immobilized and they couldn't express that they were in pain. So it turns out that the entire time they were in pain and they were incapable of screaming, or so they suffered until that second injection was given and they felt that process. Once that was established, the court said, that's cruel. We can't do it that way. Find some other drug, find some other way to do this. And there are other countries that might produce a drug, let's say, in that case, that do that, but are against death penalty, refuse to sell it, or we have to come up with one of our own, that sort of thing. Now, I realize some of you will have differing opinions about whether or not the death penalty should exist or not. That's not the point. That's something that you go and you try and change the law, right? You go to the legislative body in that state and you try and eliminate or get rid of or institute a death penalty. That's where that happens. But if your legislation on a state level is somehow cruel, the Supreme Court, when it gets to it, will say you can't do it this way. It violates the Constitution, prohibition against cruel and unusual punishment. But it's not just in death penalties, right? If you break a law and you steal something, does that mean that they have a right to take all your property? That's unusual, and there's an element of cruelty to that. A while back, with law written to stop drug trafficking, the police were given wide berth and all of that, and so the police could, if they thought you were even trafficking anyway in drugs, you got paid, you had $500 in cash, and you got pulled over for some traffic infraction, or maybe for some other reason, and you're asked how much money you have on you, and you say $500. They say, we think you're using that to go buy drugs, or we think someone just bought drugs from you. And there's very little proof, right? And they were, by law, allowed then to confiscate the money, the property involved in it. They could sell off that property, and then the money was used for the state and for the locality and even the precincts. So that was problematic. It was unusual. It was not unusual because you had a lot of places doing it, but it was really problematic, right? The courts look at that, the state level, and say, well, you can't do that anymore. And some states don't allow it. Other states have done nothing about it. So that's what we're talking about here. Remember, law gets written, regulation gets written, right? All kinds of rules get written, and then the courts have to figure out whether in a particular case something's been violated or there's some sort of merit to the argument based on the facts. Keep in mind that it's really important that legal writing and expressing ideas doesn't have to be written exactly the same. The structure should be there. There's a process to it, and it's helpful to stick with a process that's been well accepted and people are accustomed to. But nevertheless, I don't want you to think that you always have to write it the same way, or it's always written the same way. But nevertheless, if you go far afield and you write a memorandum or you find that you're writing it like a dissertation or like a college undergraduate paper, you're going in the deep end immediately. That's not how this writing occurs, because it has a different purpose, right? It has a different purpose. So if you're writing a brief, there's a process. Again, you can deviate somewhat, but you want to do it in a way that people are accustomed to it. You tend to write law. Legislative bodies tend to write law pretty much in the same way. So what are we doing here? We're writing policy, right? Law, which has to be very clear, very, very consistent throughout its component parts. And then we have issues that arise, and what we then have is the need to write a memorandum of law to a member of the law firm, let them know we think about the case based on the law. Or in some ways, we're writing a brief to the court, trying to influence the court, persuade them. So look, the law is about persuasion, right? You have a legislative or regulatory body writing something because there's a need to write it. Some problem has come up, and they feel they need to address that problem, and they write a piece of legislation or regulation to address that problem. But then when there's a breach of that or violation, somebody has to determine whether or not there's been a violation, and then what you need to do with that. So the law moves. It's living, it's breathing. It's not, this is it, okay? Even when we write law, legislation or the like, you have to make certain decisions about verbiage. And you get, law professors and scholars and judges looking at, okay, how do we approach this problem? So for example, let's just say that I rob your house. We're going to use that term, okay? Rob, normal parlance. Rob your house. Does it matter what time of day I rob your house? What constitutes a robbery? But just let's look at the time of day. And this is what the scholars and the like have to address. Should it be the same punishment if someone breaks in your house at 2 o'clock in the afternoon rather than 2 o'clock in the morning? Should those things be treated differently? And, what we've said, or what they've said, right, is, yeah, they should. Why? It's somehow more egregious to break into someone's house at 2 o'clock in the morning because they're more vulnerable. They're in the house, they're asleep, so it puts them in a very vulnerable position. Where at 2 in the afternoon, they're probably at work, there's light, others in the neighborhood can see it happening, so you're less vulnerable. So we should punish somebody perhaps more that does something like that, breaks in at 2 o'clock in the morning rather than 2 o'clock in the afternoon. It seems reasonable, right? You really want to punish a more egregious, crime, even though it ends up, in this case, taking other people's possessions. You want to punish certain things more because the circumstances are just more onerous. They're more onerous. They're more dire, so we punish them differently. Is there a rationale for that? I just gave it to you. Should that be written? Yes. So it gets very complicated, like breaking and entering, two elements, right, in the law, right, about going into someone's house. Now, what constitutes a breaking? If you knock on the door and the door opens, and you say hello, and there's no one in there, okay? If you leave, you haven't entered, and you didn't break. But let's say the door opens and you enter. Now, if the breaking part of that law, I'm not going to go into this right now, but the breaking part of it has to be satisfied, you haven't satisfied it. The government, that's, it's a criminal act, you haven't satisfied it. There was no breaking, right? But there was an entering. And there are other elements that have to be satisfied. So let's just say it's your neighbor, and Bob always borrows stuff from you. Oh, can I borrow your rake? Can I borrow this? And you say, okay. But Bob's really bad about getting it back to you. And you want to use your rake for your own lawn. And you say, I've had enough. This is going on for 2 months. I asked Bob for my rake back and never get it back. So you go knock on the door to talk to Bob. The door opens. You say, hello. No one responds, but you see your rake up against the wall. And you think, that's my rake. So you go in and you take it. Well, part of it is a taking. But can you take your own possession? You see, this is the kind of things that we're talking about here. All right, so it gets very complicated. And so, because you're setting up rules that have an impact on people, and so you better make sure that those rules can be interpreted consistently and that they make sense, right? Because that's what the rule of law is. Here's how it works, time and time again, until we change it, because it doesn't work anymore. For example, Plessy versus Ferguson constitutional law, they're separate but equal is fine. You got a water fountain, you've got a water fountain. This race has a water fountain, this race has a water fountain. You both have water fountains, no problem. A couple of decades later, along comes Brown versus Board of Education, and the court interprets separate but equal as inconsistent. They say those words don't go together. You can't have something be separate but still be equal. Reinterpretation. So therefore, everyone gets to use whatever water fountain. That's, we usually talk about a water fountain. As everybody else, right? So there's all these interpretations that change, and when they change, you've got to write new law. All right. So I just want to give you a breakdown of what's on the board, only because I think it helps put things in some perspective. Basically, we tend to think of these three are the important ones. I hate to say important, but basically they govern, what we think of as most important. Of course, they all rest here. They have to satisfy that. So typically, criminal law, some law concerning criminal activity is written, and there's a process for this in the Constitution, right? That in the first 10 amendments, it comes really, not in the first or second, but beyond that. So criminal law right? You need a process. So due process is an example of that, where everyone gets the same process. You can't have a rule of law where people get treated differently. Oh, you're not going to get to, make your argument. The other side only makes their argument. And where criminal law is concerned, one of the parties to criminal law has to always be the state, whether it's a city or what have you. And this is punishable, right, in terms of prison time or that. It's not always that. It could be, a release and a work program, whatever. But there is some punishment for it if the state wins their case. So when we think of civil law, we're really not thinking of punishment because it involves two parties, neither of which is a state in the purest sense that can go ahead and lock you up. Here, it's over equity, right? Violation of law, criminal law, equity. You owe me something, or you've hurt me in some way, and so I need to be compensated for that. So, an example here in a tort, which is when there's a tort, there's been some wrong and someone's been hurt, and someone wants to be compensated for that. Slip and fall stuff, tort. You had a responsibility to keep the grease off the sidewalk. You didn't say there was grease on the sidewalk. I came walking, went flying in the air, and bang! And now, I broke both my legs and my arms. And I couldn't work, and that sort of thing. I got fired, and it goes on and on. So here's an example of how intricate this could be. And again, I'm not going to ask you about this example in terms of any real depth, but you should understand the examples because they might crop up on the midterm or the final. So you've got a situation where every summer for 3 or 4 months, this family has rents or whatever a cottage on the seashore of this major, I shouldn't say city, large lake. And the neighbor also rents or lives in their own house, and there's two children. The neighbors, we'll say boys. So the neighbor, one neighbor has a son that's 3 years or so older than the other neighbor's son. And every summer for 3 months while they're there, they become friends. The older boy, right, likes to take the younger boy out on his jet ski. And for several years, every summer. Now, the younger boy never controls the jet ski. He just rides on the back of it. As he gets older, the mom says, he goes to the mom and says, I really want my own jet ski. And she eventually breaks down and says, okay, we'll get you a jet ski, and goes to the local jet ski store, whatever that is, and says, I want to get a jet ski for my son. And the guy says, okay, let's look at some jet skis. They look at it. And then the owner of the store says, well, we have classes that he really should take about how to operate it, what to do in various situations. And the mom says, well, no, he's been doing this forever. He's fine. Okay. Takes the jet ski. The two boys go out, and the younger boy loses control because something happens to the jet ski and goes crashing into the shore. Now the mom says, well, what happened here? Well, turns out there was a slight defect in the jet ski. So of course, mom, wants to go ahead, goes to see a lawyer and says, I want to sue the guy that sold it to me and the manufacturer because this should have never happened. Now it seems reasonable up to that point, right? Okay, well, an element in this kind of suit, a negligence suit, would be that you have to look for who has responsibility here, and on the face of it, it looks like, well, it's definitely the manufacturer because there's a default, and it's definitely the store because they should have caught the default or what have you. Well, there's various types of negligence, comparative and so on and so forth, but basically the mom's responsible. And people say, how can that be? She was offered an opportunity for her son to take these classes and learn how to deal with all these situations so he wouldn't get hurt. They took precautionary measures. In terms of the defect is seen as something that couldn't really be planned for. In other words, it happens so rarely, and it's very hard to detect. But it could happen, and in those classes, you kind of learn how to deal with that. Well, the mother's responsible. She was offered the classes. Now, so she has some responsibility here, and that mitigates those damages, right? Because, hey, you contributed to this. Had you taken the class and said they didn't go over that particular thing, even though it could happen rarely, maybe that shifts a bit. So that's all interpretive, right? Law school. You have to allow people of different races into law school. We're breaking down those walls. Okay, so what happens if you have a professor in a law school that's teaching a class and you've separated people by race and you've put up a half wall so that even though they're in the same class, this one group has been separated and has to look over this half wall, which isn't so not high that they can't look over it. And the professor basically addresses his lecture to one particular race. Now, has the letter of the law been satisfied? They're in the class. But has the spirit of it? The answer is no. And so that's how complicated things get. So that's why the writing is so important. You've got to make these arguments based on the facts. Facts are important, right, in the process. Go to law school, again, it's picking up on fact patterns. Are the facts here such that I can pull these facts and they're germane to this particular, issue, and can I win the day with them? All right, then there's regulatory law. Regulatory law is just based on different industries and different endeavors have different regulations on them. And the regulations are to guide conduct so that folks don't do things, companies and the like, that are going to damage people, right? So there's regulation. Now, what's odd about this is that courts tend to defer to the regulators more than back here to the state or even in civil matters, because these guys are experts on what the regulation means and how it's enforced and so on. It's more complicated in a sense because it's particularized. So the court gives great deference to these regulators. It's like they've regulated it. They know why they're regulating it this way. And so we're going to give them a little bit more leeway. Same thing with military law, because the military operates differently. You don't have the same freedoms with military law, right? Because you can't. Freedom of speech is more limited here. So that's different. And there's a whole mess of other laws. There's corporate law, there's constitutional law, which is really important. So it deals with all this. Deals with all law. Trust, wills, and estates, administrative law. It goes on and on and on. But the thing they all share in common is they are structuring conduct. And you must pull facts based on what's occurred to make a determination or an argument to the court that something's been violated here. Law of all kinds is about structuring behavior. If we don't structure behavior and people can act any way they want, you don't have any law. And when there's no law governing behavior, you have chaos. When you have chaos, you don't really have a civilized society. Because anything can happen to anyone at any time and no one's responsible. When you get more than one person, if you're a person all by yourself on an island, you're good. Do whatever you want. As soon as that second person shows up and you see each other, you begin to set rules for each other, right? Like, I fish, you can't come and take my fish. If you've had a bad fishing day, you can't come take some of my fish to eat it. Now, after a while, you realize either one of us can have a bad fishing day. So let's make an agreement. If you have a bad fishing day, you have a right to so much of my catch. Third person comes along. Things get more complicated. Now you got a troika going on here. Now 350 million people show up. Wow, that's really complicated. You better be very exact in the way you do things, and all kinds of sophisticated problems are going to crop up. And then you get advancements in technology and science and all of that, and then things change again. I mean, does someone have the right to take their own life? Euthanasia, right? What happens? Can a doctor assist you? Should a doctor be able to assist you? How do you know the person really has had enough and wants to die? I mean, suicide's illegal, but there's no one to punish unless someone helped, right? And so these things get very complicated. The complications require even more specificity, even more exactness. So this is on page 7. Many legal documents can be classified as having either two essential purposes: to communicate a balanced analysis or to persuade. We've already talked about that. That's why you do it. So keep in mind that if you go to law school and then you go take the bar, there's a lot of writing. Oh, there's a bunch of multiple choice questions, but there's a lot of writing. And it means going through these fact patterns, looking for facts that support a particular approach, and then writing that up. If the facts don't support it, you can't really do it. So when we talk about persuasion, we talk about briefs. And so the purpose of a brief is to persuade, this is on page 8, a judge or panel of judges to make a ruling that favors your client. The purpose of a demand letter, for example, is to persuade another party to take some practical action, such as pay a debt, drop a claim, or cease some activity that is causing injury to your client. So, the demand letter, you go to an attorney and you say, look, this person hasn't paid their rent, or, this person owes me some money. And the lawyer says, okay, we'll send a demand letter. We'll say, you got to pay this. It'll be brief, and they'll make the demand. Why? Because then everything goes away. Oh, I'll pay it. But what if the person refuses to pay it? Well, now there's a practical matter, and the law is very practical. Well, the person owes me $1,000. I've got to pay this attorney $5,000 to file the suit and go through the whole process. So I'm going to lose $4,000. So you know what? I'm not going to go after it. Think about debt that banks, bad debt. Banks give out credit cards, people don't pay them, pay their bill. These institutions think, should we go after this person? Well, there's sort of an approach here. If you owe very little, it's not worth it for them to go after. If you owe a lot, they're probably going to try and work with you and restructure it, right? Because it's a lot. So it's funny. You're better off owing, millions of dollars than, or owing, $1,500. When you get into that middle area, that's where it can become a little treacherous. You owe enough for them to file suit. Say owe $100,000, or you own a house, right? So there's actually some asset there. It's a very practical matter, and the law is practical. All right, so keep in mind that the audience dictates how you're going to write these things up and what facts are important, and so on and so forth. Remember, a lawyer's stock and trade are words, and those facts that they pull and how they get interpreted. A fact, everyone thinks a fact is just a fact. Well, not necessarily. There are elements to facts. For example, you walk by, you cross over a bridge, you're going for a walk, and you hear screaming, you look over, and there's this guy out about, 30 feet into the water and can't swim, and is yelling help. And you look over and you see them. And you just turn away and you walk away. Okay, so do you have a responsibility now to go help them? Right? Well, that depends on the facts. If the guy that didn't look over, just heard the screaming and kind of looked around but didn't see the guy, well, maybe not. Or what if the guy can't swim? The guy that sees this person drowning can't swim. No one says you have to jeopardize your life to help somebody. But what if you could swim, and what if you looked at the guy? There's an expectation that you would have helped in some way. And if you don't, that may be actionable. What about a doctor? This is the Good Samaritan law. It used to be that if a medical professional said there was a car accident, went over because somebody was hurt and tried to help, that they actually would be held accountable if that something happened to that person, they died or whatever, because they shouldn't have administered this, they should have done it that way. And so what you had medical professionals sort of standing there and saying, I can't do anything. And then, we realized, look, this is crazy. Yes, there could be problems if this person helps, but if they do help, maybe there will be a better outcome. But you can't punish people for trying to help. Okay, so it's very rational. The arguments have to be made. The legislative body holds hearings, right? Gets experts to come in and testify about what should have been done, and the like, and why it should be done, and why the law should be changed, or why a law should be written. And then the Congress, the state legislative body which writes the laws, or the regulatory body that holds hearings, will say, yeah, we need to address this problem. Law is supposed to address conflictual issues or problems that don't maximize the outcome. That's what they focus on. Do they always? No. Do they write law that benefits them and people that donate to their campaigns? Yes. This is not a campaign class, a campaign finance class. It's not, it's not a class on American government. We're not going to worry about things like issue networks and so on and so forth. If you want to know about all that stuff, you can take an American government class or parties and elections, that sort of thing. Okay, so the writing and the structuring of it helps us to understand the process and how we go about doing that. Okay, so what I want to do now is you should read the rest of that first chapter about researching the law, pre-writing, all of that stuff. It gives you a lot of sort of particulars about how things kind of work. Again, we're concerned with process because moot court, mock trial, that's really about engaging students in a process, right? Of actually presenting their case, writing up and presenting it to a court, which means they have to know the process, they have to know how to write it up, they need to know the law. So it's a very good approach. And you'll see that when we talk about the case method, which happens in Chapter 2, that cases that have been decided have made decisions about how to apply the law. So it's good if your fact pattern can fit a case, or 2 or 3 or 4, or 5 or 6 or 7, and you can bring those cases in to illustrate your point, right? Here's the rule, and I'm going to prove the rule, and then I'm going to do a rule out. I'm going to apply that rule to these facts in my case and show you, because the law should be consistent, that what happened in these other cases and the way the court defined the verbiage and defined the rule and so on and so forth should be applied here. And therefore the outcome here should be consistent with those outcomes in those cases because the law should be consistent. If it's not, there's no law, right? Should be consistent. And once it's consistent, and you've demonstrated that, you've now said to the court, so, hey, you got to decide in my favor. The other side is doing just the opposite, right? They're looking at the facts, calling those facts, getting other cases that may not necessarily support, the decision the other side wants. Now, think about this rationally. The cases you're going to use are going to be the cases that are most relevant to that particular venue. If the case is sort of state-bound, then you want to use cases, let's say it's New York, you want to use cases that have happened in New York, right? If it's a federal case, you want to obviously look at federal cases. You don't want to go to other jurisdictions if you don't have to, because New Jersey and New York are separate states. But if there are cases that happen in New Jersey that sort of support your argument, they're not primary, but they might help. Not as much as a case that actually happened in that jurisdiction. But, you work with what you've got. So the case method is a really important way. They give you a case here. This is on page 15 in Chapter 2. They give you Hadley versus Baxendale. I'm not going to go over that case, but if you go to the next page, page 16, it gives you, some sort of structure of it. Now, it's in pounds, so I don't, the actual payment and stuff. It illustrates, though, because a lot of that stuff comes from English law. But nevertheless, you can see that there's an agreement on a contract, there's a performance and a breach of the contract, and there are complications there. Think about it this way. I order from you all the time socks. You're a sock company, and I sell socks in my store. So for 10 years, you've been selling me socks, right? And I order purple socks. People love purple socks. I want you to send me, 1,000 pairs of purple socks. That company makes a mistake and sends you, because you have a contract, you had an offer, I'll pay you money for 1,000 socks, right? And you had acceptance. Okay, we'll send you the socks. So there's the fundamentals of a contract. Offer, acceptance. And so they've accepted it, right? You made the offer, they've accepted. Now, if you offer to pay $1 million for these socks, and they say, no, we need $1 million, we need 1.1 million, that's a counter offer now. So the original offer has been rejected. There's a counter offer. Now the other side that made the original offer has to decide whether or not to accept that. That's how it goes. All right, so what happens if you don't get, all those purple socks? You get red instead. Okay, has the contract been satisfied? On the face of it, no. But is this person liable? Well, suppose the person keeps the red socks and sells them. Mitigated damages. Things change. So you see what I'm getting at here. It's not straightforward. And lawyers spend a lot of time structuring these things. So here you have an agreement, performance, and a breach. They didn't do it. Then there are consequences. Someone's been damaged or hurt. There's a demand made to, hey, fix this. There's a response that refuses to fix it. And then they go to trial. And then one side claims this much in damages. So much is offered in settlement. And so on and so forth. Then there's a problem and it goes to an appellate court to review. That's the fundamental process here, right? You'll notice that there has to be something that we've agreed to in this particular case, and there has to be a provision of that that's not been met, a breach. But you have to suffer from it. The guy sold the Red Sox, right? And so on. So you can read that case. It's interesting. It illustrates the point we're getting at. In Chapter 3, we get to the sources of lawmaking. And we focus on lawmaking because laws, right, are what we operate off of. We operate off of laws. We don't operate, willy-nilly because we just want to operate that way. It doesn't work like that. So there's different types of law. So there's common law. There's natural law. You have a right to eat. So you don't need someone to write law saying you have a right to eat. Now, do you have a right to steal food? Okay, so there was a case a while back where somebody is fishing, in a government stream or what have you, and it says that, you have to catch and release. Catch the fish, you release the fish. You can't take the fish and eat the fish. And there's some guy that goes fishing there, takes the fish, goes eats the fish. Government finds out about this, and they're going to punish him. Because it says, government property, have fun fishing, but you got to release your catch. You can't take them home and eat them. This guy did that. So did he violate the law? Yes. It's written. He went before the court and said, I don't accept this court's authority. I have a right to feed myself, and I have no place that I live. I have no money, and I needed to survive. So I don't care what law you've written. There's a higher law, right? I have a right to sustain myself. And I don't accept this court's. This court has no right to be hearing this case. He stood up and he walked out of the court. And nothing happened. People kind of looked at each other and said, what is he doing? Just, I refuse to accept your authority here, and left. Now, think about that. If the law forces you to die, other than, execution and all of that, because they deny you a fundamental way of sustaining yourself, well, then guess what? There's a real issue, right? You have a right to sustain yourself. So it's not always clear, right? The law is written and then the enforcement of it. To enforce a law that so damages someone that it could end their life because they took some fish and they ate it. It seems that the crime doesn't fit the punishment, or the punishment doesn't fit the crime. And what do you do with that? Maybe you say they have to go clean up the bank of the river or something, but even there. So on page 24, at the bottom, it says, they talk about the judicial branch of government, and that develops law in two ways, both of them in the context of particular disputes. First, their state and federal courts contribute to the development of constitutional and statutory law. Statutes are written rather than the Constitution. By interpreting the necessary general terms or elements here, right, of such enacted law and applying those terms to facts of disputes. Facts that support your argument, right? Second, as offspring of the English judicial system, which has informed our system greatly, Courts in the United States have adopted and continue to develop a substantial body of common law, judge-made law that applies to issues that constitutional statutory law does not address. This is a major problem. We're not going to go into it. We talk about it in common law. Common law is not statutes. It's not written by a legislative body, but the courts interpret a law and, in a sense, add to it, take from it, structure its meaning. So a source of common law, federal courts no longer create and develop federal general common law, nonetheless the federal courts retain the power in a few restricted fields, such as admiralty law and so on, to develop specialized federal common law. So you'll notice that the graph says Constitution above, then there's executive, legislative, judiciary. The executive executes the laws that are written by legislative bodies, but how you enforce those laws changes the intent, or can change the intent of the legislative body. So a particular piece of legislation has 4 parts, but say the President of the United States doesn't like one part. Now they can veto the entire thing, right? They can't just veto that one provision. But what they can do is not enforce that one provision. So in effect, they have rejected that provision. So there's manipulations, and then the Congress would have to come back and go through a whole bunch of hoops to try and limit the president from doing that. So people often think that a president, by vetoing a law, is the only way he does that, but the president can simply just not enforce it or enact it. All right, the Constitutional Legislature enacts statutes, right? Judiciary issues case law. They get cases. And as they write case law, which is nothing more than an interpretation of the statutes of the Constitution, the words, they're interpreting the words based on the facts in the case, and they're saying this is how we interpret it. And that develops common law, obviously with roots in early common law and equity. We want to be consistent. If the law, again, is not about consistency, it's really about nothing. Then there's historical roots of common law, and the fact that common law is always in constant change, because why? Facts change, particulars change. Laws don't apply forever. The argument that whether or not the Constitution should be interpreted differently, constructionism and so on, things change. And law that can't adapt can't really give the consistency that's necessary to the entire structure. So the summary here is very straightforward, right? Legislatures enact statutes is on page 28. Legislators enact statutes within the authority granted to them by state and federal constitutions. Courts create case law in the context of individual disputes. 1, by interpreting and applying the provisions of constitutions and statutes. So they have to first define what those statutes and that provision of the Constitution means. Words. And developing and applying separate body of judge-made common law. The common law continually grows as new cases present what? They're going to present different facts, right? So common law kind of keeps things up to the changes that are going on in society. So as an impact or a consequence of this, you get all kinds of considerations that you have to make or have to meet. All right. There are also, in Chapter 4, the roles of constitutional and statutory law. These are very different things. Think of constitutional law. Well, obviously, it's in the Constitution, but all of this has to be consistent with provisions here. Now, not all violations, right? You have a right to go to the court of first instance, the original court, and you have a right to one appeal. In other words, Scalia said this pretty accurately, I think, that you have only a right to one appeal. No one says that a higher appellate court or the Supreme Court has to hear your case. You had 2 bites at the apple. Court of original jurisdiction in the process, and now an appellate court. And that's it. There's no guarantee it has to go beyond that. Can it? Yes. What determines that? Usually the appellate court sees something important in that case that needs to be resolved, and so they resolve it. The Court of Original Jurisdiction, they feel made a mistake, and so on and so forth. They're going to correct it. Now, it could be that the appellate court makes an error, and let's use the Supreme Court because it's the last court of resort. Supreme Court says, the original court had this right, and we want to clarify this point. The appellate court had it wrong. And then the final arbiter of the law is the Supreme Court. You can't appeal beyond that, right? So typically the court, although we don't really know completely and accurately why they choose certain cases, but usually if there's a dispute between the courts and interpretation, words, interpreting them, the Supreme Court's going to probably jump in there, not always, and basically, become involved in it. So on page 31, it says the Constitution states the framework for all law. Just what I've said, right? Legislation is one, they say great tool, along with that, of legal change and readaptation. Again, adjusting. You can't have the law remain stagnant. All right, so that's really important. And obviously, a little further down, other three branches of government, the legislature is the paramount policy-making body. They write policy. Presidents execute it, courts adjudicate it. Here's the policy. Has it been enforced consistently, and so on. And consistent with that role, of course, you get the idea of how it has to go through other courts. So they give you an example of embezzlement. You should read that. It helps clarify. Look, cases and looking at various statutes and how the constitutional provisions are interpreted gives clarity, great clarity around what exactly is paramount, or how that law is looked at or viewed. All right. So consumer protection legislation, you should read that as well. There are particulars there, but the two boxes at the bottom, common law of contracts, consumer protection legislation. So if store's ad is not an offer, customer makes first offer. Store can reject that offer and can switch customer to more expensive item. In other words, if you go into a store and you say, well, I think this is too expensive. I want another, I want a break price. And so that's the offer. I want to pay $3 less. And they say, well, look, let me show you something else. They've rejected your offer. You know where you see this a lot? On internet, sites. So, for example, it's not so much a bait and switch, like you get this and then give you that. It's, you want to buy something, and it really looks like a great product. And all of a sudden, you go to purchase it, and it says out of stock. And they don't know when it's going to be restocked. Or all of a sudden, you come back to purchase it an hour later, and now everything is out of stock. But the more expensive ones aren't out of stock. So they made an offer that they would sell you this computer, let's say, for $900. You come back, and they say out of stock. We can't sell it to you. So now the offer's been withdrawn because they don't have the stock. But you can buy this other computer for $1,200 or $1,300 or $1,400. We do have that in stock. There's nothing wrong with that. There's nothing wrong. It's frustrating. But there's consumer protection legislation, right? And they make decisions about that. You should read that, okay? So they talk on page 33 about the increasing significance of legislation. There's a lot of legislation. And it gets more and more complicated because issues get more and more complicated. But if you look down at the judicial interpretation and application of statutes, it's about words again. Look, a federal statute imposes liability on certain employees for discrimination against any individual in the terms or conditions of employment because of each individual's sex, gender, right? Now, think about that. It says, would the statute impose liability on an employer who fired your clients, lesbian and gay employees, because of their sexual orientation? Would it impose liability? It gets more voluminous. The next part, here you have it, vagueness and ambiguity. This is why we fight things out in court. It's one of the reasons. Questions such as these arise because statutory language, words, is sometimes vague or ambiguous. Why is it so? Because sometimes the Congress, they always say there's two things you don't want to see being made, sausage and legislation. There's compromise. And there's all kinds of different things put in there. In the case of the Senate, again, it could be a rider. Again, this is not a custom of the American government, but that's an example of it. So when you have a vague term and it's uncertain, then you got a problem with scope. And so again, the court looks at it and says, what do you mean by this? Sometimes they'll write ambiguous law because they want to pass it and they can't get enough agreement without it. But then the law is really ineffective because it can be interpreted in so many ways, and it's really passing the responsibility onto the courts to clarify the law. Here we wrote it. You guys interpret it and let us know what it means. And you've got Congress people that have said as much. We don't know what this means until the court tells us. The court is passive, and the court's not going to go out there and try and, make a decision about everything that you've done. Every possible interpretation and the like. And the courts really prefer to sort of stay out of that. You should read on page 35 where it says statutory construction when interpretation fails. But it's really the next page 36, which lays out graphs, box graphs. I like these things, just so you know that I very seldom pass over these and just discard them because they give a lot of information in a very simple form. And that means in terms of exams and the like, you don't want to necessarily just blow these things off. Here, it deals with evidence of legislative intent. We got to know what they mean by the words, right? What do they intend to fix here? So, intrinsic evidence and extrinsic evidence are different. So, intrinsic evidence start with statutory language. What did they mean? A clause in question, defined terms, statements of purpose, related statutory provisions, and a statute as a whole. This is what you look at when you're trying to write and you're trying to challenge something. You have to look at this interpretation, right? If the statutory language is ambiguous, or if extrinsic evidence would otherwise be helpful, you have to consult the extrinsic evidence of legislative intent. What do they mean? And then they have the extrinsic evidence, right? Primarily legislative history. What have they done in the past? The past will help us understand what they wrote here, right? So if the legislation intent remains unclear, you seek guidance from general rules of construction. They did it this way. Why they do it this way? Why they put it together in this manner? So you construe criminal statutes narrowly in favor of lenity, right? Because you want to make sure you don't add more on than they intended, because obviously if it's criminal, there's someone who's suffering a penalty based on it. So you want to be very careful with that. Avoid a construction that would render a statute invalid or a clause superfluous. Courts don't want to do that. They wrote it. We don't want to negate the law. Oftentimes that's the case. The courts understand that the legislative body can go back and rewrite it, and in rewriting it that they could clarify the issues the court is having with it. And that makes perfect sense from just a legal process. Now in 37 we get to case studies and statutory interpretation. I'm going to stop here because I don't want to run over an hour. I think that's more difficult for students to keep their focus. And also this is a good place to stop because this now moves us into another area. We're going to get through lecture 2 and probably lecture 3 in the next couple of weeks. Just so we can keep things moving. You need to read all of this. You need to extract everything from it. There's a lot of information here, and and you need to make sure you fully understand. Now, you should have read, all of this. You've had the first week of classes to do that. I recognize not everybody does that, but I like to give the lecture after people have sort of gotten the reading done, so they already have some sense of the landscape, and I'm clarifying, giving them examples, and showing them what's important. If you do it the other way around, you don't have any frame of reference, and you're trying to get the complete frame of reference from me, but I'm making the assumption you've read, and so you have some contextual base for what I'm focusing on and what I am expanding on. All right, make sure you read. The next lecture will probably be up sometime, later next week. But you'll be made aware of that. And you should keep up with the lectures and keep up with the reading. It looks like a lot of reading, I understand that, but don't think of it in its totality. Think of it as lecture by lecture. I'm going to do lecture 1. He's halfway through lecture 2. I'll try and get through the end of lecture 2, so when he finishes that up, I'll have some clarity around it. And then, I'll probably do lectures 3 and 3 by itself, and I'll probably do 4 by itself because 4 is pretty voluminous, but we'll see. Okay, so get to the reading, keep up on the reading, and make sure that you get through the lectures, really being able to piece things together, write things in the column. There's lots of room to write things off to the side here in the way this has all been photocopied, so make sure you do that. Okay, lecture 2 is coming up in about 10 days.